All right, I call cause number 10,858 for the case style, the state of Texas versus Jacob Dreger, Driedger.
Yes, sir.
And this case is called for purposes of conducting an arraignment. And let me announce that this arraignment hearing is being conducted by remote video teleconferencing technology using the Zoom protocol for that purpose. It is also being live streamed on the court's YouTube channel,
Okay.
both of which are to satisfy or comply with Texas Supreme Court and Office of Court Administration rules, orders, and directives that we do so. All parties are prohibited from recording this proceeding or any portion of it by any means, except for the official court reporter who is making a record of this hearing, just like you would do if we were in open court in person. We are not. We're doing this virtually. For purposes of the arraignment, is the state ready to proceed?
State's ready, Your Honor.
Sir, are you Jacob Fear Dreger?
Yes, Your Honor.
How do you pronounce your middle name?
Fair, F-E-H-R.
Yes, sir. Thank you. Mr. Dreger, an indictment has been returned into this court charging you with a third-degree felony offense of driving while intoxicated. Have you received a copy of that indictment?
I don't believe so.
Yes.
It was yellow.
Yes. Oh, yes, yes.
All right, sir. That's it. Yes, sir. And are you currently out on bond on this charge?
Yes, I am.
You have the right to have someone read the indictment out loud to you here in court. So let me ask you, do you wish to have someone read the indictment to you?
Yeah, I would have to because my eyesight is real bad. Everything's just blurry.
Very well. We will read the indictment to you. Mr. Smith?
Yes, Your Honor. The state of Texas versus Jacob Fair Dreger. In the name and by authority of the state of Texas, the grand jurors for the county of Scurry, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January-June term AD 2021 of the 132nd Judicial District Court for said county, upon their oaths present in and to the court that Jacob Fair Dreger, on or about the 16th day of January 2020, and before the presentment of this indictment in said county and state, did then and there operate a motor vehicle in a public place while the said defendant was intoxicated by not having the normal use of mental or physical faculties by reason of the introduction of alcohol or a controlled substance or a drug or a combination of two or more of those substances into the body, or by having an alcohol concentration of at least 0.08. And the grand jurors aforesaid do further present in and to said court that prior to the commission of the aforesaid offense on the 18th day of January 2012 in cause number CR 043911 in the county court of Scurry County, Texas, the defendant was convicted of the offense of driving while intoxicated. And on the first day of May 2019, in cause number CR 009619 in the county court of Scurry County, Texas, the defendant was convicted of the offense of driving while intoxicated against the peace and dignity of the state, signed by the foreman of the grand jury.
All right, Mr. Dreger, you've heard the reading of the indictment. Do you understand that it charges you with a third-degree felony offense of driving while intoxicated?
Yes, sir.
In the indictment, is your name spelled correctly?
Yes, it is.
And is Jacob Fair Dreger your true and correct name?
I'm still good.
But his not.
Right.
I don't recall we've ever had that problem over there.
Mhm. I'm sure it's called tomorrow.
Don't know what they can do about it. Turn the heater up.
Judge,
Yes.
the jail informs me that their internet is down. And Hannah asked if we want her to put her phone up there.
You mean to get on Zoom?
Yes.
If she can do that, yes.
Marvin say anything? Yesterday.
Kayla, I think today will be as good as any other time. Tomorrow would be better, but if we can't get them today, and unless it's today, then let's do it.
The county judge informed me that they called him out of the blue and said, we're coming today. So
Okay.
it's something that was set up.
All right, that's fine. We'll do it. It appears we have you, Ms. Counts, but you're muted.
Okay, can you hear me now?
Yes, ma'am.
Okay, the internet just came back up on it at the office.
Okay.
So do we want to proceed with my phone or do we want to go back to the laptop?
I think the laptop would provide you with more flexibility. And so let's try the laptop. And if we have a breakdown, I do appreciate your assistance.
Yes, sir. There you go. Use that.
All right, Mr. Dreger, we continue on the record in your arraignment. I had just asked you if your name was spelled correctly in the indictment, and you advised me that it was. Is that correct?
I believe so. Dreidger.
And all right, sir. And Fair is F-E-H-R,
That was my mom's maiden name before she got married.
but is that correct spelling?
Yes,
All right, sir. Mr. Dreger, this charge, as I've mentioned, is a third-degree felony charge. The range of penalties for a third-degree felony runs from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, the institutional division. It also includes the possibility that a fine could be imposed. If so, in an amount not to exceed $10,000. Do you understand that that's the range of penalties that exists for a charge such as this one?
and that's I understand.
All right, sir. Understanding the charge and understanding the range of penalties that this charge carries, to this charge, how do you wish to plead, guilty or not guilty?
I wish to plead not guilty.
All right, sir. Do you have an attorney representing you?
I do not.
Are you going to employ your own attorney?
I have no way to pay him. I haven't been working since December, and I have no money.
And so do you want to ask for a court-appointed attorney?
If I could, yes.
Yes, sir.
Yes, sir.
We are just about through with your arraignment, but we will not be totally finished until you have filled out a request for a court-appointed attorney and presented it to me. To do that, I'm going to require you, as a part of your arraignment, to come to the jury room on the 4th floor of the courthouse. In other words, when I say you're excused, I mean you're excused from the room there in the law enforcement center, but you will come directly to the courthouse and to the 4th floor, to the jury room.
Okay.
Now, there is also one other piece of paper, a document for you to sign. The deputy will provide it to you. It's called Acknowledgement of Arraignment. You should look at it. It's supposed to say what we have already discussed.
Okay.
If I ask you to look at it, satisfy yourself that that is what it says. And in the bottom left-hand portion of the document, there's a place for you to circle your plea. You said your plea is not guilty, so just circle the not guilty, then sign that paper.
Okay.
Bring it with you when you come to the courthouse in just a few minutes.
Can I have my son help me with that?
Yes, sir.
I've
Is he
lost
with you?
him. He was outside. I don't know if he left or Connie said he could leave, and then we was going to call him when I was finished here.
All right. And so is he going to bring you up to the courthouse?
Yes, he will.
He can come in with you to the jury room and help you make sure you understand what that paper says. And then I will talk to you again before you leave.
Okay.
All right, do you have it? That's a good question. Do you have any other questions?
Not at the moment.
All right, thank you, sir. You may be excused. The deputy will assist you in stepping out of the room.
Thank you, Your Honor.
Thank you, sir.
This will explain to you about your acknowledgement of arraignment. That's what he explained to you.
Mhm.
I need you here, sir. Guilty. Judge, do you just want him to take this form with him and so his son can tell him a little bit more about it, just not him sign it? The arraignment?
Well, the son will just read it to him, but yes, let him take it with him.
Okay.
Do you have the request for court-appointed attorney form with you or there at the jail, Randy?
Yes, Judge, I do.
Then let him have both of those and he can bring them to the jury room here at the courthouse in just a few minutes. And someone will make sure he has filled that out correctly, will notarize his signature, and then he'll be through for the day.
Yes, Judge.
I say, Mr. Dreger, if you are given a court-appointed attorney, you will have one other obligation. You will have to go across the street to the probation office. When I say across the street, it's across the street from the courthouse. And you will have to register for what's called bond supervision. It has more to do with your appearance for court next time. That's what it's about. It's not about you and your bondsman, but that will be explained to you when you go there as well. And I'll talk to you more about that when you finish filling out your request for court-appointed attorney.
Thank you.
All right, sir. You may go. You'll get the two papers, the two documents from Mr. Romero, the deputy, and you will bring them to the courthouse with you.
Okay,
All right, sir. Thank you.
thank you.
Mr. Smith, what I plan to do is call these next cases and call each one of them and if there is no response, then I'll ask Deputy McAden to go call their names distinctly at the courthouse door and perhaps have Mr. Romero call their names there at the law enforcement center as well, cover all bases before we issue a warrant.
All right, Judge. Sounds good.
Do y'all have any more arraignments that are there in the jail or at the law enforcement center this morning?
Yes, sir. Two more. We have Monica Mayfield and then Patrick Miller.
Okay, good. Let's go ahead and do Miss Mayfield.
Okay. Oh, you did? Come on. Let's see.
Are you Monica Lynn Mayfield?
Yes, sir.
Miss Mayfield, I was just about to say, while you're in the law enforcement center in front of that laptop and in this court proceeding, you may remove your face covering.
Thank you.
Thank you. All right, let me make some announcements and then I'll speak with you again, Ms. Mayfield. I call cause number 10,859 for the case style, the state of Texas versus Monica Lynn Mayfield. This is an arraignment hearing or proceeding, and it is being conducted by remote video teleconferencing technology using the Zoom protocol. All parties are appearing remotely. The hearing is also being live streamed on the court's YouTube channel, all of which is to comply with the Texas Supreme Court orders and Office of Court Administration rules and directives, providing access to the public and providing health safety to all participants. As a result, I further advise that all parties are prohibited from recording this proceeding or any portion of it, except for the official court reporter, who is in fact recording the proceeding as he would do if we were in person in the courtroom, which of course we're not because we're doing this virtually. For purposes of arraignment, is the state ready?
State ready, Your Honor.
And are you, once again, you are, or are you Monica Lynn Mayfield?
Yes, sir.
Ms. Mayfield, an indictment has been returned into this court charging you with a third-degree felony offense of driving while intoxicated. Are you out on bond on this charge?
Yes, sir.
Did you post a new bond or make a new bond or have a new bond substituted for you when you were arrested on this indictment?
Yes, I believe Connie has another bond to me.
All right. You have the right to have someone read the indictment out loud to you here in court. Have you had a copy, have you received a copy of the indictment? It should be the yellow page. Yes, ma'am, that's it right there. Even though you have a copy, you still have the right to have someone read the indictment to you. Do you wish to have someone read the indictment out loud to you?
No, sir.
Do you understand it charges you with a third-degree felony offense of driving while intoxicated?
Yes, sir.
Your Honor, it's actually a state jail felony.
I'm sorry, I didn't look at all of it. My bad. I apologize to you, Ms. Mayfield. And looking at it further, I can see that that is the charge. It's driving while intoxicated, alleging that there was a passenger in your vehicle younger than 15 years of age. That's the allegation. And it is a state jail felony as alleged. So let me talk to you about that indictment. First, is your name spelled correctly in that indictment?
Yes, sir.
And is Monica Lynn Mayfield your true and correct name?
Yes, sir.
Ms. Mayfield, as I mentioned, the indictment charges a state jail felony offense. A state jail felony carries a range of penalties running from 180 days up to 2 years in a state jail, and carries the possibility that a fine could be imposed. If so imposed, it could be in any amount up to $10,000. Do you understand that's the possible range of penalties you face if you were to be convicted of this charge?
Yes, sir.
Now then, since we have discussed the charge and the range of penalties for the charge, let me ask you, to that charge, how do you wish to plead? Guilty or not guilty?
I'm not guilty.
Do you have an attorney representing you in this charge?
I will have an attorney.
All right. Is it your plan to employ your own attorney?
Yes, sir.
Have you made efforts to do that so far?
I'm supposed to speak with Kenny next week.
I'm sorry, you're supposed to talk to whom?
Kenny Maxwell.
Okay. All right. That concludes most of your arraignment process this morning. Because of the COVID restrictions, we have been doing this by remote technology, as we've already discussed. To complete the process, and you are not complete and through with your arraignment until it is completed, the deputy will hand you another document, or will hand you a document entitled Acknowledgement of Arraignment. It is designed to say what we have already discussed. Examine it, look at it. If you're satisfied that that's what it says, then on the bottom left-hand part of the document, there's a place to note your plea, either guilty or not guilty. You said your plea is not guilty, then just circle not guilty and sign your name. Then you must bring that document to the courthouse. In other words, go straight from the law enforcement center to the 4th floor of the courthouse. If you have any questions about that document, bring it on up here. Don't sign it until you have a chance to ask me your questions. When you get here, we will direct you to or you will go to the jury room here on the 4th floor of the courthouse. And there is another laptop set up, and you can get at that laptop and ask me any questions that you have.
Okay.
All right. Do you have any question before you start to ask questions?
No, sir.
All right, then that concludes the first part of your arraignment process. All that's left is for you to bring that document. If it is signed, bring that to me here at the, come to the jury room on the 4th floor. We will retrieve it and make sure it's your signature, and then you'll be excused. All right, thank you. We'll see you very shortly.
Yes, sir.
Go ahead and open it.
I'll probably have to go ahead and click on it. and we can never-
Because they were waiting a moment.
Judge, we're getting Patrick Miller next.
Thank you.
You'll keep it yellow on the, yes, sir. All right, we'll see you.
I didn't notice the video in the jury room.
No. Are you Patrick Miller?
Yes.
Mr. Miller, while you're in that room in the law enforcement center there in front of the laptop, you may remove your face covering. Thank you.
Sorry.
Makes it easier for us to hear you. It also makes it easier for you to breathe. And
Yes,
so,
they are hard to breathe with.
yes, sir. All right, Mr. Miller, I'm about to call your case for arraignment purposes. I'll have to make some announcements on the record, and then I will get back with you specifically. Your cause number 10,861 for the case style, the state of Texas versus Patrick Miller. This case is called for purposes of arraignment. The case is being conducted or heard by remote video teleconferencing technology using the Zoom protocol. The case is also being live streamed on the court's YouTube channel to allow, well, to accomplish or to comply with Texas Supreme Court orders and Office of Court Administration rules and directives to allow the public to have access to the courts. Since it's being provided in this manner, I advise that no one, all parties are expressly prohibited, and therefore no one may record any portion of this proceeding by any means, electronic or otherwise, except for the official court reporter, who will transcribe the proceeding just like he would do if we were in person in the actual courtroom instead of this virtual courtroom. With those comments made, for purposes of arraignment, I ask State's Attorney, are you ready to proceed?
State's ready, Your Honor.
And Mr. Miller, are you in fact Patrick Miller?
Yes, sir.
Mr. Miller, have you received a copy of the state's indictment in your case?
Yes. I
That
did.
would be the-
That yellow piece was, yeah.
Yes,
I
sir.
did.
That yellow page
Yeah.
that set
I
out what
have
the
that.
charge? All right.
Yes,
Are you currently out on bond?
yes. Yeah,
All right, sir. And I also see that you received or should have been served with a copy of the indictment 2 days ago.
yes.
All right, sir. You have the right to have someone read this indictment out loud to you here in open court. Do you wish to have someone read the indictment out loud to you?
I've read it. I read it and pretty much understand it, I guess.
All right, sir. Do you, nevertheless, I need to ask you if you want someone to read it to you again.
I suppose it.
All right, Mr. Smith, would you read the indictment to Mr. Miller?
Yes, sir. In the name and by authority of the state of Texas, the grand jurors for the county of Scurry, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January-June term AD 2021 of the 132nd Judicial District Court for said county, upon their oaths present in and to the court that Patrick Miller, on or about the 13th day of November 2020, and before the presentment of this indictment in said county and state, did then and there, with intent to fraudulently obtain a benefit, use a debit card, namely a First Bank and Trust debit card with last four digits of account number 3859, with knowledge that the card had not been issued to the defendant, and with knowledge that said card was not used with the effective consent of the cardholder, namely Antonio Perales Jr., against the peace and dignity of the state, signed by the foreman of the grand jury.
All right, Mr. Miller, do you understand that that indictment charges you with a state jail felony offense of debit card abuse?
Yes,
In the indictment, is your name spelled correctly?
yes.
And it's
Yeah,
Pat,
I didn't see any mistakes. I didn't see any mistakes in it when I read it myself.
all right, sir.
I
And
wouldn't
is
have-
Patrick Miller your true and correct name?
Yes,
Mr. Miller, as I've mentioned, this charge is what's called a state jail felony. A state jail felony carries a range of penalties running from 180 days up to 2 years in the state jail, and carries the possibility that a fine could be imposed, if so, in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face for this charge?
yes. I don't understand Texas law that much, but it's a lot different.
I understand. But my question, this simple question is, do you understand that's the range of penalties that exist for this type of offense, this type of charge?
Yes,
All right, sir. Understanding the charge and understanding the range of penalties that you would face if convicted of this charge, to this charge, how do you wish to plead? Guilty or not guilty?
I mean, I am not sure, to be honest with you. I don't know what to do, because it's just like, you know what I mean? I mean, there's a whole lot behind it. You know what I mean? There's a lot more than that's even any of the courts know. Like I still have things that I have to do on my end.
All right, sir. May I suggest that,
I'm trying to get a public defender. So, one of
hold
them.
on, don't get ahead of me,
Okay, I'm sorry.
that you reserve all of your options and enter a plea of not guilty at this time that will not be used against you or held against you. And it wouldn't be used against you if you enter, well, it will not be used against you or held against you if you enter a plea of not guilty. If you later decide to change that plea, or if it turns out that that plea is incorrect, it still will not be held against you or used against you.
Okay, so I just don't, yeah, okay, then let's, until I get the public, whoever I'm gonna use, I guess I would go not guilty then.
All right, sir.
Yeah,
Hold on. My next question is, do you have an attorney representing you?
not yet. Like I said, I just got indicted for it. Like,
Right?
I didn't, I've talked to, it was 3 months ago when I talked to the officers about it, when they interrogated me about it, and it happened to be my landlord's partner. And I'm going through a deal with my landlord right now that they kind of, it doesn't matter. It's like, to tell you right now, it's probably, it's off the wall, it's not. But
That's right. This is not the time to
right,
discuss.
I don't want to get into that kind of conversation, but, because I know you don't have the time for that, but, so.
My question is about the attorney. Do you plan to hire your own attorney, or are you requesting or do you wish to request a court-appointed attorney?
I think I'm gonna have to do the court-appointed attorney. Like yeah, I'm not gonna be able to afford, because, I've already put people out on, I've already spent enough of my friend's money to, I'm not gonna spend any more, you know what I mean? To just get out. So it's like, I'll just get a court-appointed attorney, I guess.
Well, it's not a matter of just getting one. It's a matter of being eligible for one. You're talking about spending other people's money, which may indicate that you don't have the money yourself.
Yeah, I don't. And I got a good friend here that was kind of been there, because I just lost my mom 13 days before this happened. And he's kind of been there for me, because I'm not, I'm kind of all alone out here. So it's like,
All right, sir. I will give you the opportunity to request a court-appointed attorney. But to do so, I'm going to require you as a part of this arraignment. In other words, you're not through with court yet. You're going to have to bring some papers to the 4th floor of the courthouse in just a moment. Do you have transportation?
no. I do if I really need it. Yeah.
No, I mean right now.
Transportation. So how far?
2.5 miles.
I mean, I could within a couple, as long as my friend's a funeral director, so it's like, as long as there's no funeral, yeah, I do.
How did you get to the law enforcement center this morning?
I walked.
All right, sir.
But I mean, I can get there within time, either way.
All right. You will be required to bring your written request for a court-appointed attorney to the 4th floor of the courthouse, and to do so this morning. You will also be required to bring with you a document entitled Acknowledgement of Arraignment. The deputy there in the law enforcement room with you will give you those documents. You bring them with you to the courthouse, to the 4th floor, to the jury room on the 4th floor. And there in the jury room, someone will assist you in making sure you fill out the request for court-appointed attorney by answering all the questions that are necessary. I will also then speak to you again because there is another laptop set up there in the jury room, and we will speak to you again and give you a chance to ask any questions that you have about the acknowledgement of arraignment form. I will tell you ahead of time that form was designed to say what we have already discussed, but I want you to satisfy yourself that that is what it says. And if you're satisfied that that's all it says, there's a place in the bottom left-hand part of that document to circle your plea of not guilty and then sign the document on the bottom. If you have any questions about what that document is actually saying and you're not sure, then don't sign it until you have talked to me again on the laptop at the courtroom, at the courthouse, and I'll answer your questions then. But if you don't have any questions, you can go ahead and circle your plea of not guilty and sign it, and I'll talk to you just to confirm that you have done that. All right, sir?
All right. How much time do I have? How
You
much
got
time?
30 seconds. Hurry.
No.
All right, good. You understand my humor. You have to be here this morning. How long do you think it will take you to get here?
Are you there? No, or get there? How long?
I don't know.
Where exactly is it?
There's, for the courthouse, you know, where that, a few directions.
Okay. If I walk, how long? If I walk, how long? Oh, okay. All right, but if I call it, I could be there, is 40, if I said I can be there in 45 minutes, is that good?
Yes,
That
so
way I
that will work.
don't, or within the hour, I'll be there. Just,
That will work.
I'm gonna try to call for a ride.
All right.
'Cause I don't really know the area that well yet to, you know, I do, but I don't want to make any mistakes. I don't want to not be there.
I understand. I don't want you to make a mistake either.
So
And I
I'm,
don't want you to not be here. So I will give you certainly 45 minutes. You should be able to walk here in 45 minutes or less.
yeah, he
If
said
you
20,
get a
25
ride.
minutes. So I'm gonna try to get a ride, but if I have to walk, I'll walk.
All right, sir.
All
So you will be here before 11 o'clock and we will take it up again with you.
Okay,
All right. For now, you may be excused. I will see you on the jury room laptop in less than an hour.
okay. And
All
thank
right.
you.
Thank you.
Just for information's sake, I have walked it in 45 minutes.
Judge, that's all we have right here.
All right. Ms. Counts, we're going to call some other these other cases and I will ask Mr. Romero to go out into the area where people have been waiting and call these names also,
Okay.
and then report back to me. Okay.
Okay.
That is Mr. Romero ready for that?
Yes.
All right.
All of the 11 o'clock, all of them are in custody with the exception of the Skylar Holman.
I tell him I got a ride.
All right. Well, we'll do the 11 o'clocks at 11, but you're saying they're all here?
Yeah, they're all in custody.
Oh, okay.
Yeah. So we'll be ready whenever you are.
I appreciate that. We're going to have to get the defense lawyer in custody probably to get him here at 11. All right.
Okay.
Thank you.
He's gonna talk to you.
Yes, Judge.
Yes, sir. I'm going to call several cases and I anticipate that they're not going to show up. Deputy McAden is going to call their names here at the courthouse. And if you will call their names there back in the waiting room where we have directed everybody at the law enforcement center, and then report, we'll take a report on all of them at the same time.
Yes,
Does that work?
Yes, sir.
All right. I call cause number 10,857 for the case styled the state of Texas versus Estela Beatriz Vieira, Vieira.
Okay.
Ms. Vieira has not appeared at the courthouse or the law enforcement center. Therefore, her name will be called distinctly 3 times at both places by deputies of the Scurry County Sheriff's Department. I next call cause number 10,860 for the case style the state of Texas versus Crystal Ann Plunkett. Crystal Ann Plunkett is not appearing at the courthouse or the law enforcement center as to participate in this hearing, and to give her the chance of possibly being here but not in view of the court, we're going to call the name of Crystal Ann Plunkett distinctly 3 times at the courthouse door. Next call, cause number 10,862 for the case style, the state of Texas versus David Ramirez Mojica, Mojica.
Your Honor,
Yes.
that's a failure to appear case. Do you show that he had been arrested and bonded on that? I don't show
Oh.
that he'd been arrested at all.
Okay. No, I'm sorry. I do not show his arrest on the new charge, so he is never bonded on it. So at this point in time, there's no reason to call his name.
And I think the same would go for the last case on my list, Joseph Rowe. I don't believe he's been arrested at all.
And has never been on bond on this charge.
Correct.
Okay. So we're calling the names of Estela Beatriz Vieira, Crystal Ann Plunkett. Those are the only 2.
Judge, can you explain the situation? Though I was told, I hadn't been verified by me in regards to Estela.
Hold on. I've been told also, but
Okay.
we're going to call her name anyway,
Yes, sir.
and then we'll see. What the deputy, I understand, is about to say is Miss Vieira is, we believe, is incarcerated in a city jail in Harris County. A bondsman is in the process of trying to bond her out, or has actually bonded her out, but there is a possibility she is still incarcerated. And if that turns out to be the case, then obviously we will not pursue a warrant. We will just reschedule her for arraignment. And there is some indication that there is something similar with respect to Crystal Ann Plunkett. But she has been bonded out, so the report goes, but has not appeared this morning. The report to the court is that she may just show up sometime this afternoon, at which time we will have to explain to her it's not her scheduling that determines when she shows up, it's the court's scheduling. But for right now, Deputy Romero and Deputy McCaden, if you would call these 2 names distinctly at courthouse and law enforcement center doors, I'll wait for your report back. Thank you.
Yes, sir.